building the foundation for justice and rule of law. This panel will focus on the relevance of SDG 16 and the protection of sustainable development by ICL. As providing effective access to justice is key, we have to understand which are the elements that we have to analyze, and also to understand which are the synergies between the agenda and the field of international criminal law. For this panel, we will have as a chair Dr. Glaucia Boyer. She has more than 15 years of experience working with the United Nations and strategic planning and policy development on issues related to governance, rule of law, security, and peace building. Currently, she is the policy advisor at the United Nations Development Program. Glaucia, please.
Thank you very much, Eduardo. And I wanted, of course, to start by thanking the Nuremberg Academy for inviting the United Nations Development Program to chair this panel. And as we see, the topic here now is about justice and rule of law. And after reflecting on the Agenda 2030 more broadly this morning, this panel now is zooming in SDG 16.3. So it is about promoting the rule of law at the national and international levels and ensure equal access to justice for all. So we discussed about measurement also this morning, and we have the indicators. So indicator 16.3.1 focus on the proportion of victims of violence report, and 16.3.2 on unsentenced detainees as a proportion of the overall prison population. Despite the fact that we are zooming in 16.3, our focus is also on the relevance of the Sustainable Development Goal 16 and how, in particular, justice and rule of law play out in the overall achievement of the SDGs. We at UNDP, we like to think about justice and rule of law as enablers of the entire Agenda 2030, along with peace and also inclusion. And I think with the notion of inclusion, we have this whole notion of leaving no one behind and reaching the furthest behind first. But before turning to our panelists, I wanted to say just a few words on the SDG 16. It is an incredible achievement just to have SDG 16 among the goals. It is the result of years of political, strategic, scholarly work by human rights advocates, development practitioners, and academics, just for us to get there. And this morning, much has already been said about justice. We are aware that there are billions of people around the world today living without adequate protection of law. We see also access to justice as the cornerstone of human rights. UNDP had already described back in 2004 access to justice as a basic human right and saw it as indispensable to combat poverty, prevent and resolve conflicts. We're already talking about people-centered justice at that time. And of course, it's so key to have it finally consolidated in the goals, in the SDGs. I think as part of this panel, it would be perhaps very useful also to recall that the reference to access to justice in SDG 16.3, of course it is for all, but on the other hand, it's not qualified, meaning that it refers in the end to both civil justice and criminal justice. It also refers to the different forms of justice. It doesn't qualify, but it is broader. It is about retributive justice, restorative justice, distributive justice, and here perhaps we can also talk about transitional justice. I think it's perhaps helpful here also to look at the definition that the International Center for Transitional Justice proposes, saying that it's not a particular type of justice, like restorative justice or distributive justice or retributive or punitive. It is the application of a human rights policy in particular circumstances. It is not soft justice. It is the attempt to provide the most meaningful justice possible in the political conditions at that time. I think another point is also, Navi Pillai this morning recalled the definition of rule of law. Sam Miller reminded us about the importance of data collection, analysis, measurement. So to complement the reference made to Navi Pillai this morning, I wanted to go back also to the World Justice Project definition of rule of law and the effort about measurement, because I think we're looking much beyond. And here we say that effective rule of law reduces corruption, combats poverty and disease, protects people from injustices, large and small. It is the foundation for communities of justice, opportunity, and peace, underpinning development, accountable government, and respect for fundamental human rights. I think then the importance of measuring here this rule of law as well, in the 8 factors that are used. And we see then again, among these 8 factors, also civil justice and criminal justice, which brings us to our topic here. Also, the importance of our panel, it has been referred this morning that we will be soon reviewing the progress at the high-level political forum in July. And before that, we also have the expert group meeting on the SDGs 16 coming up in May in Rome. And we have an infinity of consultations, e-consultations, workshops, webinars about the SDG 16. And we are, I think, all aiming here also to contribute to this review. So our 3 panelists here are going to share with us their experience on this topic. And I propose that we hear first from Maaike de Langen, second from Marieke Weerda, and certainly, and lastly, but certainly not least, from Dr. Rancharan. So I think I would like to pass the floor to Maaike de Langen, who is head of research for the Task Force on Justice. I think here we have an incredible opportunity to hear directly from her. She's coming from the World Justice Justice Forum, where the report, Justice for All, has just been launched. And she's going to be able to share with us her perspectives on that, and maybe the inside story as well. Over to you.
Thank you very much. Good afternoon, everybody. Thank you, Lausja, for this introduction, and thank you to the Nuremberg Academy, not only for inviting me, but also for choosing the 2030 agenda as a topic for its conference that we are having here. I work at New York University at the Center on International Cooperation, where I have led the research for the Task Force on Justice, as was just mentioned, and indeed for Just 4 days ago on Monday, we launched the report of the Task Force on Justice in The Hague, the city of peace and justice. So it is a great pleasure to be here today. And what I've learned today, that Nuremberg is the city of peace and human rights. So what better bridge to make in this first week of that we now have the final report of the Task Force on Justice. So I will share with you some key elements of that report. But first, let me take a step back. Other speakers have commented on this as well, but I'd like to look at the adoption of the 2030 agenda. I'm not an expert on the topic, but I do know, and this has been said this morning, that it was not easy to get SDG 16 included as part of the 2030 agenda. There were both ardent supporters and there was also strong opposition. And there was heavy campaigning from civil society, from the Office of the High Commissioner of Human Rights, etc., etc. And there were a number of countries that showed leadership to get it done, get SDG 16 included. A key concern in those debates was whether including such a goal in a development agenda might divert resources from development to security. And then, of course, another was the long-standing concern that it would compromise national sovereignty. Proponents, however, focused on the universal nature of this goal. Justice is something for everybody. Everybody understands justice in the most basic sense. It's one of the first things that children say when they interact with each other. That's not fair. So it's universal. This goal has a universal nature, and all countries need to work on it actively to strengthen justice in their societies. Proponents also work to shift the focus of the debate from advocacy around the problems to really identifying solutions and seeing what can be done to make progress. So once the goal SDG 16 had been adopted and access to justice was therefore included, there was an even bigger challenge: how to deliver on this promise of SDG 16. And using the same key ideas, universality of this aspiration and a focus on solutions, a group of countries and organizations came together and formed the Pathfinder for Peaceful, Just and Inclusive Societies. This is a group of countries and organizations, as I said, that work together loosely, but very focused on those solutions. And in the first phase of their work, they developed a roadmap for peaceful, just, and inclusive societies. And they took a very broad approach to SDG 16, and they developed this notion of SDG 16+, which actually links the 12 targets of SDG 16 to 24 other targets in the 2030 agenda that directly measure some aspect of peace, justice, or inclusion. We also say that justice, and that's the approach that the task force has also taken, justice is not limited to 16.3. It is part of the overall goal, but justice is also a thread that runs through the entire 2030 agenda, and that is actually, it underpins the achievement of all the Sustainable Development Goals. So one of the initiatives of the Pathfinders was to set up this task force on justice, to really get a group of people and countries together to chart a course on what is needed to deliver on access to justice and justice for all. The task force on justice has worked a little over a year. It was led by Minister Germán Garabano, the Minister of Justice of Argentina, Minister Priscilla Swartz, Attorney General and Minister of Justice of Sierra Leone, and Minister Kaag, the Minister for Foreign Trade and International Development of the Netherlands, together with Hina Gilani of the Elders. So there's strong political leadership both from UN member states and from civil society organizations as the Elders. The task force was composed of experts and practitioners from around the world. In the research that we did and in the work streams that we set up, we created opportunities for a wide range of people and organizations to contribute to the work. These justice partners, as we call them, included multilateral organizations such as UNDP, the OECD, the World Bank, justice-specific organizations like the World Justice Project and HIL, academic organizations, international NGOs and campaigns such as Namati and the Justice for All campaign. Now the report is called Justice for All, in line with SDG 16, which promised equal access to justice for all. A number of things have been said already about data and measurement this morning, and Sam Muller in his presentation mentioned some of the key numbers that are included in the report as a first global estimate of the justice gap. The global justice gap, which is composed of 253 million people who live in situations of extreme injustice, and we consider that situations of modern slavery, statelessness, and state fragility. 1.5 billion people who have unresolved justice problems, and indeed that includes both civil and criminal justice problems, and the report also looks at what are the 6 most common problems that people face around the world. And 4.5 billion people who do not have their papers in order. They do not have legal identification documents, no contract for their work or official registration for their business, or they have no title to the place where they live, no lease or property for their home or land. So the task force has identified this as the global justice gap. That, of course, is an impressive number. 2/3 of the world population do not have meaningful access to justice, and that tells us something about the scale of the task ahead of us. The costs of these different aspects of injustice are tremendous, and the task force worked also to develop a better understanding and a more shared understanding around the costs of injustice, both at the individual level and for societies as a whole. We worked with the OECD, and they estimate that countries lose as much as 0.5 to 3% of their GDP due to unresolved justice problems, mainly due because individuals who have those unresolved problems suffer health consequences or loss of income and loss of productivity, and also because there are impacts on the economy as a whole and society. So that gives us a little bit on the size and the scale of the justice gap and the costs and the benefits of investing in justice. Based on this analysis, the task force concludes that what we need is a shift from a system that provides justice for the few to a system that provides justice for all. And there's actually a shocking agreement, or I would say a broad agreement and a shocking acceptance of the fact that rich people have better access to justice than poor people do. There's nobody who disputes those facts. You can, of course, debate the numbers and the methodologies of measuring it, but everybody seems to agree with that, and that should be a strong motivator for all of us to work to promote access to justice. So in order to do that, the report then focuses, and the task force focuses on the need to resolve people's justice problems and prevent justice problems. Solving justice problems requires a better understanding of the problems that people face, what types of problems, what is the context in which they face them, and based on this analysis, a structured investment in creating better justice journeys. What do people actually experience while they are trying to resolve their problems? That requires empowering people and communities to know and use the law, and providing access to services that actually meet the needs that people have. And finally, it requires that we ensure that justice systems contribute to fair outcomes. Now, there was already some discussion about measuring those outcomes. I think that's a very interesting field for all of us to, the next step of work, to really think through what those justice outcomes look like and how they can be measured and achieved. Some key elements in these, in improving justice journeys are investing in legal empowerment, providing legal aid, simplification of processes, and tailoring services to specific needs, such as one-stop shops or specific problem organizations around specific problems that people face. Fundamental to fair outcomes, of course, I don't think I have to explain to this audience, is the respect for human rights and the need to offer the right remedy. There are several levels at which the task force has looked at the issue of justice as prevention. Justice systems need to contribute to the prevention and de-escalation of disputes, both at the individual and at the community level, and preventing violence as a result of conflicts. Grievances that are not sufficiently addressed can lead to instability and conflict. And in the report, we use the example of the Arab Spring and the street vendor, Mohammed Bouazizi, who was confronted while he was working he was a street vendor and he was working very hard for very little income, and he was confronted with authorities that had no understanding for his situation. he was refused a permit, or his skills were taken because he didn't have a permit. But to this day, nobody knows if he actually needed that permit. So these kind of injustices and the fact that he could not air his grievances led for him to this dramatic moment where he lit himself on fire. But with those grievances, he sparked the entire Arab Spring. Justice systems have a role to play in preventing those kind of grievances to escalate and leading to conflict and violence. Justice systems also have a positive role to play when it comes to promoting inclusion and protecting rights. And a key component of justice as prevention is the need to create trustworthy justice systems. So the task force calls for people-centered justice systems, and the Agenda 2030 as a whole is a people-centered agenda. Justice not just for the few, but for all. So how do we get there? There are many good examples from throughout the world, and many of those examples have been included as the report for others to learn from, and not necessarily to copy and paste, but to take inspiration from and to discuss and to apply to their own context. Based on all these experiences, the task force has identified 4 levers for reform. 1, and much has been said on this already, use data and evidence to drive reform. 2, innovation. Innovation, not just high-tech innovation in new apps and websites, but also low-tech innovation, including other actors, changing procedures, changing approaches. 3, use smarter justice financing. Why do we spend so much money on things that we know do more harm than good, like cracking down on crime, locking people up, not adjusting our criminal justice systems to the need of young people, for example? And 4, build more coherent and inclusive justice systems. Include other actors, focus not only on courts and lawyers, but on paralegals and other people who can support people in finding solutions to their justice problems and opening up the system. It is impossible to do justice to the whole report in a few minutes, but I've tried to give you a bird's eye view of some of the key elements and recommendations. I will leave it at this, and I invite you all to read the report. There's a few copies still remaining here, I think, and it can also be downloaded from the website. The work of the Task Force on Justice has had strong country leadership. I started with that. And an ever-growing group of countries and organizations are coming together to work towards solutions for the justice gap and to make real progress on justice for all. We are working to strengthen this political engagement, linking the global debate of the Agenda 2030 to national actions and actions at the local level. And Minister Swartz of Sierra Leone, for example, was a co-chair of the task force. She was telling us just this week that the fact that she was a member of the task force and being a member of such a global discussion has actually empowered her in her own cabinet meetings where she has to negotiate with other ministers for budget for the justice sector. And it has strengthened her in her resolve to adopt reforms in a national context. At the global level, there are other steps that have been mentioned. I won't go into the details because I'm running out of time, but the voluntary national reports, the high-level political forum in July, and then up to the SDG summit in September, where the Agenda 2030 as a whole will be reviewed. Now, finally, in the process of the task force, we've brought together different groups of people. They were mentioned as silos or fields. You can even think of them as tribes, working in the justice sector globally. We have worked with the justice data nerds, as you might call them, economists who look at justice sector from an economic perspective and helped us make the case for investment, grassroots activists and human rights lawyers, transitional justice experts, and those advocating for justice for women and justice for children. I'm very happy to be here today in this other tribe of international criminal law. I may not have the right customs of this tribe because I'm wearing, I didn't know we were supposed to wear dark colors, so I'm very bright here. But I hope to engage with all of you and bring a new group of people and actors together in our work on justice for all. Thank you very much.
Thank you very much, Mike. And I think we would like also to hear from Dr. Maria Kvierda, who is also coming from The Hague and from the World Justice Forum. as Netherlands chairs the Task Force on Justice. She is among the members of this panel, the true expert on international criminal law, and will share also her perspectives with us. And of course, I wanted to seize the opportunity to thank, on behalf of the UNDP Global Program, for the support that Netherlands has afforded to us, and also to provide all the assistance that is necessary in building capacity for member states to be closer to achieving the Sustainable Development Goals, in particular 16, SDG 16.
Thank you very much. It's a pleasure to be here. And I want to really commend the Nuremberg Academy for the choice of combining these two topics, SDG 16 and international criminal law, which are both issues of tremendous importance to the Netherlands. But I should say, this is a tricky presentation for me because I will first say 2 words in my official capacity, and then I will change quickly from being a bureaucrat to being someone who recently completed some scholarship with Karsten Stan, who's in the room today, on the impact of the ICC, which I think is important to talk about. And indeed, it's along the lines of the question that was raised by Philip earlier. How do we measure justice? And in this case, I looked at how can we assess the impact of the ICC. But let me just say 2 words in my official capacity first, just to thank Maaike for giving us insight into what this Task Force for Justice is trying to do. I should say, on behalf of my minister who sat on the task force and who continues this work, this is a top priority for us. So for the Netherlands, it's not just about producing this report and not just about going to the high-level political forum and trying to elicit concrete commitments from states about how they're going to advance the justice agenda. In February, we brought up to 20 ministers of justice to the Netherlands and encouraged them to think about the commitments they're willing to make in this process. In June, we will bring another, we think, up to 18 ministers of the G7+. These are the most fragile and conflict-affected states. We hope they will do the same, and we hope to continue this process. And we really hope to bring the kind of shift that we've all talked about, where justice becomes really much more central to the development agenda in the coming years. So just to say how important it is and what the opportunity is that the SDGs provide, because they are a universal agenda. Our justice minister is at the table the same as all the other justice ministers, and we have things wrong with justice in the Netherlands, and we're willing to talk about that. But it's also really an opportunity, as others have said, to break down these silos and to build a community that seeks to build more peaceful, just, and inclusive societies. And this is what we seek to do. Having said that, I will now trickily switch roles, and I must emphasize what I'm going to say next is not in the official position of the Dutch Foreign Ministry, but I wanted to talk a little bit about the research that I had the chance to do for my PhD, where I looked at 5 countries, and I had 2 goals. One was to try to devise a framework to measure the impact of the ICC on country level. And these are the countries for which the SDG 16 was made. They are fragile and conflict-affected countries. But also then, apart from devising a framework, to then also concretely look at whether the ICC is living up to some of the expectations, of course, by spelling out those expectations, whether they are fair or unfair. And that's something that I wanted to present briefly today. But first to say, before I go there, to connect the 2 presentations, Maaike talked about the justice gap, and she talked about those 253 million people who live in extreme conditions of injustice. And I think those are the kinds of conditions for which international criminal law are devised. So the report talks about many situations that will be much easier to solve than those situations. And of course, in countries where governments themselves want to apply SDG 16, it's a far different situation than countries where the governments themselves are the prime abusers of their people, such as Syria, etc. And I think that's really the challenge of ICL. But in reality, also, if we look at not leaving anyone behind, those are the problems we have to resolve, because also development experts tell us that by 2025, 4 out of 5 poor people will live in those conflict-affected states. So those are, in essence, our target group in this agenda. And having said that, I think all of us in this room probably are agreed, and Judge Pillay said it much more eloquently, that the goals, the norms of SDG 16 and international criminal law, they overlap significantly. And they're extremely noble, and they should continue to command our attention and our respect. So the norms, anything from reducing violence and armed conflict, fighting impunity, prevention, protecting the vulnerable, women and children. Betty Murungi spoke about that, and will tomorrow too. Institution building and promoting the rule of law. These are all the values that we seek to, the norms that we seek to promote. So I think the real challenge then is on the implementation of these norms. So what I tried to do very quickly is I tried to, in form of a case study, drawing on my PhD research, try to overlap some of the norms of SDG 16 and of the ICC, and taking the breakdown of peaceful, just, and inclusive. So on the one hand, we can say maybe we should look at a deterrent effect, because that would build more peaceful societies. And I think most of us would still agree that one of the main goals of the ICC through fighting impunity is to prevent the kind of atrocities that occur during conflict, and maybe even prevent conflict itself. Then also we can look at a more transformative effect to see if the ICC is contributing to impact in the first instance on peace processes, but maybe in the much longer term in building more peaceful and just societies, because it's guaranteeing justice within peace processes. A systemic effect could look at the impact on legal systems, which should build more just societies, but should also guarantee access to justice, including, of course, for the most serious crimes. And then finally, if we look at impact on victims, I've referred to it as reparative effect, but this is to do with also with whether victims are getting the access to justice that they expect. But one can also say that's a contribution to building more inclusive societies, because the victims of Rome Statute crimes in particular tend to be amongst those most marginalized or those most disempowered in a society, because they tend to bear the brunt of these crimes. And the Rome Statute preamble refers to the children, women, and men affected by these atrocities. So if we take that as a framework, and I don't want to take too much time, but a deterrent effect I'm not going to say a lot about, because I think it's simply, there isn't a lot of reliable empirical evidence one way or the other. There are many attempts, I think, to start to look at this issue and to see if in situation countries that are under the scrutiny of the ICC there is a reduction in violence. But I think it's still difficult to say. What we do know, I think, more about is the Pathways for Peace report was referred to. We do know that there is a rise in armed conflict worldwide since 2010, and quite a rapid rise in the number and intensity of conflicts. And some of these, of course, are in non-member states, but this is concerning. And we do also see that the fact that the ICC has a situation under scrutiny doesn't necessarily prevent violence in Sudan, in Afghanistan, in Libya. There are a number of examples of that. But so on this one, I think we will need more time to really evaluate. But we do know a little bit more about the impact on peace processes. And these are the 4 situations that I looked at. I should have mentioned Afghanistan, Colombia, Libya, and Uganda. On this, we can see that there was quite some impact in the Colombian situation in how both in how the peace process ran as a process, including, for instance, the participation of victims directly, but also in the content of the peace agreement in terms of having this special jurisdiction for peace which will conduct national trials. And we see a little bit of similar impact in Uganda. It also has this International Crimes Division which is trying one case. And it had a different kind of peace process because of conducting this in the shadow of the ICC. But we also see a mixed situation with amnesties still being pursued. There's a full-fledged amnesty in Afghanistan. And in fact, in Afghanistan, there's until now very, very little discussion of justice in the very nascent peace talks that are being held there. And in Libya, also, it's an issue that's not much discussed in spite of the fact that several senior Libyans are under ICC arrest warrants. The next issue, just to talk briefly about systemic effect. I think it's very relevant to look at systemic effect. Many scholars like to use the language of complementarity, and this has given rise to some scholarship about whether complementarity is in fact a development concept and whether it can be used by development practitioners. Personally, I have a few misgivings about that because I think complementarity is a technical concept, and naturally the ICC itself is focused on individuals and usually on a small number of individuals, but this often translates at the domestic level that national authorities who are seeking to avoid ICC jurisdiction also look at relatively limited numbers of cases. This is usually in the context of far wider rule of law challenges that need to be addressed, including if you take post-Gaddafi Libya, there was no independence of the judiciary. Then they started a whole system of what they called political isolation, which they wanted to use to vet the whole judiciary. And then militias were running the country, occupying the justice ministry. All this is very difficult to tackle any of those kinds of challenges through complementarity. Plus, it's also a bit about how issues are understood, because there were domestic trials in Libya that fell under complementarity. But how much of those trials were, how was the access of the population and how are they viewed? Were they seen as fair or unfair? These are very difficult questions. So I, have some questions about the term complementarity, but what I think is most relevant is there an internalization of the norms and values of the Rome Statute at the domestic level? Are countries themselves internalizing, and how do they show that? Well, obviously by changing their laws, by also adopting norms, not just in implementing legislation that defines the crimes, but also in procedures, in victim procedures in particular. Do they set up new bodies to try Rome Statute crimes? And most of all, are they actually conducting national proceedings? And here we see again a slightly mixed picture, but with a number of good positive examples. One that stands out is Afghanistan, which maybe others will bring up today in light of the pretrial chamber decision. But just to say that Afghanistan incorporated Rome Statute crimes, not necessarily because they felt that if they don't do so, the ICC will immediately step in, but they did it because they thought it's important. And indeed, there is a small unit now in the prosecutor's office in Afghanistan, and it's looking at these crimes and seeing what they can do to prosecute. In the first instance, they're actually looking at only crimes committed by ICL, and that may be a little bit political, but it's a start. So we do see some progress here, and one may also be able to anticipate that with time, there would be more internalization. But then we come to the last one, or the reparative effects and the effects on victims. Both, do they have more access to justice, and, in a sense, are they being empowered in a way that would build more inclusive societies? And on the country level, I think there is kind of a problem with the impact of the ICC in this front, because although there is this issue of victim participation, it's also been much discussed and much written about the extent to which victims are able to meaningfully participate in trials in The Hague. But also, there are clearly expectations that exceed what is being able to be delivered. And I think it should ask us to cause us to ask some tough questions about whether the modalities that we have in international criminal law on victims are being built in a way that they can really contribute to these broader goals as laid out under SDG 16. So then very briefly by way of conclusions, as I said at the beginning, there is this opportunity to break silos under the SDGs. And my belief is then also that the SDGs offer opportunities for international criminal law to both extend its legitimacy, but also to sharpen its practices. And one of the issues that I think we should do, and Sam Muller emphasized it this morning, but we should try to move a little bit more from what Karsten has called from the faith-based to the fact-based by, number one, clarifying our assumptions about what international mechanisms are meant to deliver. And if one looks at the ICC in particular, I think one can conclude that the assumptions have been extremely ambitious on occasion and also very, very diverse, but definitely not very clear most of the time. We then, once we have our assumptions clear, then we should collect data on the impact. And as we learn more about the effectiveness, then we have to also be willing to adapt and or willing to look at which models are the most effective at reaching our goals or at meeting those assumptions. And in this respect, it strikes me that international criminal law is not a shortcut. We always run into the dynamics on the ground, and neither the ICC nor SDG 16 itself is, the utopia. We still have to do all the hard work in the specific context. My last rallying cry then would be for, I do think there is a lesson about how if we were more victim-focused in international criminal law, how that would give us opportunities to contribute more to SDG 16. Because I do think perhaps there can be more that we can do to meet their needs rather than think in the confines of victim participations or reparations as part of judicial trials, etc. We can really take that much broader, and other speakers have talked about it a lot, about surveying, how they understand justice, what do they want for justice, and how we can address really the problem of scale of victims. How do we deal with these very large numbers? I think transitional justice, again, can provide also a lot of experience and a lot of answers. But to be honest, on both of these agendas, SDG 16 and ICL, we also have to be a bit humble and realize that maybe we don't know everything yet, and we have to be open to keep on learning and to keep on adapting so that we can really meet the normative goals that are overlapping in both these fields.
Thank you very much, Marieke. I would like now to pass the floor to Dr. Rantaram. The program states him as the formerly United Nations High Commissioner to Human Rights, but there's so much more to his experience. For many of you, he was one of the drafters of the Agenda for Peace, where a lot of this discussion has started, and also part of the mediators team in former Yugoslavia, and former director of the Africa Division of Department of Political Affairs. So over to you. Thank you very much.
Thank you very much, Chair, and thank you to my panelists, and thank you to the Academy for bringing me here today. Eduardo wrote to me and asked me if I would speak on the application of SDG 16 in the context of fragile states and post-conflict settings. And this is what I shall address. But I have some general remarks, if I may, beforehand. I listened with much admiration and interest to High Commissioner Pillay this morning, and to the judge who was, and one presented challenges and the other presented options. And as I listened to that discussion, I couldn't help myself but thinking of Leibniz, the great philosopher, the German philosopher, his two great principles: the principle of contradiction and the principle of sufficient reason. And the principle of contradiction comes to me because I'm seeing out there, as the judge said this morning, a world in great crisis when it comes to human rights. And I'm seeing at the same time the promise and the hopes in SDG 16. And I'm asking myself, how can we reconcile these two worlds? Because I'm not really seeing the reconciliation of these two worlds. I just want to put that before you. And then when I think about options for the future, I'm asking myself the question, how can one put building blocks down in the future to help implement SDG 16? I think that there's a case here for strategic choices. And unless one recognizes the need for strategic choices, one is a bit, how shall I say, missing the target. I want to address first the issue of fragile states. Now, we can take this issue of fragile states in two contexts. We can take the issue of fragile states in the context of perhaps states that may be on the verge of interstate conflict or internal conflict. Recently, I did a paper. I'm from Guyana in the Caribbean, and I recently did a paper on the Caribbean international security and international law. And I read a statement by the Jamaican Prime Minister who's saying that when we talk about these issues of international security and the prevention of violence, we have to remember this issue of violence within the state as well. It is a security issue for us and for the international community. So this fragile states presents these two dimensions. Our chair was kind to mention that I was the first drafter of Agenda for Peace, and I wrote a book called Preventive Diplomacy at the United Nations. I'm not trying to impress you, I'm just reasoning with you. Preventive Diplomacy at the United Nations. And I have a book that I'm polishing called Contemporary Preventive Diplomacy. Now, it is not an easy matter to prevent conflicts between states. Our Ambassador Muk was telling me that Muk, did I say it right? Yeah, okay. How should I say it? Muk. Yeah, okay. He was ambassador to Libya, and he reminds me that we crossed paths at the United Nations, friendly paths. And so he was ambassador to Libya, and we were discussing the Secretary General's mission to Libya. In 2008, Secretary General Ban Ki-moon sent me to Georgia. Could I take a look and assess the peace process there? And when I went there to different parts, capitals, etc., I was told that the month of August is the month in which war is very likely. So therefore, one interlocutor said to me, send a constant stream of visitors to Georgia in the month of August. And then I thought of recommending to the Secretary General that he should make a visit to Georgia in the month of August. And then the British ambassador said to me, but if you recommend him to go there, and he goes and it doesn't work, then he has fired the one bullet that he had. So anyhow, this issue, I edited a book called Conflict Prevention in Practice, and there's a case study there of when Eritrea and Yemen nearly went to war over the Hanish Islands. And there you see a Secretary General exercising preventive diplomacy in a situation of fragile states. So, now, I don't want to dwell too much in the context of preventive diplomacy. I want to come back to the implementation of SDG 16 in fragile states. I want to ask you to think about the state of the world. Climate change, poverty, inequality, conflicts, terrorism, bad governance, gross violations of human rights, displacements of people, political tribalism, injustice, and human rights are under assault. So remember Leibniz's principle of contradiction, the world that you're trying to bring about and the world that is actually here. I want to address this issue first because SDG 16 has these chapters of peace, justice, inclusiveness, and strong institutions. And I will take justice first. We could say that governance is justice. And of course, governance is a problem. You have to look at Freedom House's 2019 report on the decline of democracy in the world, and governance is a problem. So there's the issue of governance and justice. Amartya Sen, in his book on justice, he presents a treatment of justice as prevention. How can we prevent some of the ills that affect societies? Equality is justice, and you have been speaking about the administration of justice and international justice. When I reflect on this justice chapter, I'm asking myself, what are the issues that are being addressed in the documentation in the justice chapter? And I see issues such as registration of childbirths, persons incarcerated without trial, the state of the courts, the number of people being killed through violations of human rights, and the plight of human rights defenders. And then the reason I'm saying this is that there's this issue of justice before us, and then there are all of these issues. And I really must tell you quite candidly, it has occurred to me, although these issues that are being tackled are relevant, are they really central issues? But I shall move very fast. I go now to the chapter of peace. Secretary General Guterres, in his, I think it was his end of the year message in 2018, perhaps at the beginning of this year, he issued a red alert for humanity. And one of the things he says is that the number of conflicts is on the rise. And so we're all talking about preventive strategies. And now, what are the issues being discussed under SDG 16? The role of development and prevention, something that I have much respect for from our colleague from UNDP, Peace and Development Advisors, and the UNDP Crisis Bureau. These are some concrete things. But the issue of justice and peace, I've addressed. Now this issue of inclusivity. There is a book by a Yale professor called Amy Chua, and the title of the book is Political Tribalism. In different parts of the world, people are closing in into tribal identities. There is a British philosopher called Kwame Anthony Appiah. He's half British and he's half Ghanaian. And he's just written a book called The Lies That Bind. And it addresses the issue of identity. So when we're talking about inclusivity, we have to address this phenomenon of political tribalism. We have to address this issue of the need to bring back one to identities. Let me address quickly the issue of institutions. I've already mentioned the decline of democracy. Now, when you talk about institutions, unless there is democracy, all of these things, pardon me, you're talking about access to justice and whatnot. I come from a country called Guyana, and the United States State Department just issued a blistering report on its justice system. So I put my own country on the line there. So now, this issue of democracy, and now this is a period of strong men rather than strong institutions. And populism was mentioned earlier. So now, Eduardo, you asked me to speak about the implementation of SDG 16 in fragile states. And what I have done so far is to place some issues before you that you may reflect upon. Now, I want to address the issue of post-conflict societies. About a decade ago, there is a book on post-conflict peace building, and I was given the task of writing the chapter on, quote, a peace process in the post-conflict peace building phase. And in that chapter, which I have before me, I found myself arguing that even in your context, the post-conflict settings, the post-conflict peace-building situations, we must have strategies for early warning and prevention. We must have strategies of preventive diplomacy. We must have continued peacemaking. We must entertain the possibility of peacekeepers and peace observation, and we must pay attention to development and equity. I was speaking to our chair about a rather brilliant peace mediator in Angola, Maitre Bay. When I was director of the Africa 1 division of the political department, Maitre Bay was dealing with Angola. And Maitre Bay kept coming up with obstacle after obstacle after obstacle. and issues of disarmament, demobilization, and what's the other word? Rehabilitation. And, right. He had brilliant blueprints for this. Well, where was he to find the resources? For 3.5 years, I was with the peace mediators in the former Yugoslavia, and the structure of our conference was, we had something called the Economic Issues Working Group. It was meant to prepare for economic development in the aftermath of peace. And people were interested in this working group while the conflict lasted. The moment the conflict finished, nobody was interested in economic reconstruction, etc. So now this issue of the post-conflict settings, it presents conceptual challenges and it presents these practical challenges. Now I see before me the director of the Nuremberg Academy, and I'm asking myself, sir, what might I say to you possibly that might be of value as you think about programs for the future in this nexus of SDG 16 and the implementation of SDG 16 in fragile states and post-conflict settings? I want to say to you, if I may, that I think that one of the most important issues facing us is the issue of the reaffirmation of universality. I will not go into this issue now, but universality is under great threat from the great powers. There's a great political scientist called John Mearsheimer, and John Mearsheimer wrote a book called The Tragedy of Great Power Politics, and he has a new book came out last year called The Grand Illusions. And in this book he says great powers like the United States, Russia, and China, they have no interest whatsoever in human rights. It doesn't feature in the language of realpolitik. And now, in the midst of this, we have these strongmen, and we have other currents. And so I felt, without becoming too explicit, I have felt that there is a case for leadership on this issue of universality. And so I say to you, sir, that universality is an issue. I have the feeling that from where you are situated, the whole discussion here is proceeding in terms of the role of international criminal tribunals. I have a feeling that you should not ignore the possibility of a world campaign against crimes against humanity, because sensitization on this issue is a route to address crimes against humanity without necessarily going to the angle of courts. I would say to you that the strategic centrality of national protection systems, every state should strive to have in place a national protection system. Unless the protection of human rights is taking place within a country, we are in a loser's game. The international protection of human rights cannot supplant the national protection of human rights. That, of course, is part of the rationale of SDG 16. I want to say, if I may, that more political development officers, I find a lot of value in this institution. You may explain what these political development... Peace and development officers, yes, exactly. I want to say that I think that I see much value in UNDP's Crisis Bureau. And I want to end with this. The Universal Declaration of Human Rights says, "The will of the people shall be the basis of the authority of governments. This will shall be exercised in periodic elections which shall be free and fair." Unless we are able to tackle this issue of genuine democracy within countries, we are in a loser's game. So, Eduardo, my friend, fragile states, post-conflict states, the crisis in human rights, the hopes in SDG 16, in Leibniz's principle of contradiction. A thing cannot be the same as its opposite. And so I'm done. Thank you.
Thank you very much. With all these rich reflections from our panel members, I wanted to open the floor for questions and answers, but I think we also want to look at this continuing dialogue So we can have questions and answers, but I think we want to hear also your reflections and try to build on what you have heard from the panel. So let me ask you to keep it concise so we have more, we can listen to more colleagues. And also please state your name and institution before your intervention. Thank you. Please.
Thank you very much for a wonderful panel and illuminating discussions. My name is Vivian Dietrich, Deputy Director of the Nuremberg Academy. I'd like to pick up on the issue you meant, the reaffirmation of the universality, and like to zoom out slightly to two questions that have, preoccupied us in terms of track records of states, in terms of human rights records. One question pertains to why states actually in the first place let themselves be bound or become parties to human rights treaties and in a way constrain their own actions. That's the question of commitment. And then the second question pertains to whether such treaty commitments or commitments into other instruments actually lead to an improvement of human rights, which is the question of compliance. So I'd be curious how you see the UN Agenda 2030, and especially the inclusion of SDG 16 and 16.3, as a crystallization point for this question of commitment and question of compliance for states, and linking back again to the affirmation of the universality ambition that you just mentioned. So I'd be curious how you see in the last 3 years this question of commitment and compliance actually, what's the variability or the nuanced picture that you would paint today? Thank you.
Have a second intervention. Thank you.
Thank you very much for a very enlightened and very rich discussion. The question that I want to pose is in terms of what Dr. Ramcharan said, that without the national basis of justice, realization of international justice is an illusion. There was always measurements on national justice. Article 2 of the Convention on the Civil and Political Rights have already mentioned legislative, judicial, administrative measures for implementation of human rights, and human rights included all the basic things of the justice. Now, over these years, how much has been done in the review of the Article 2 performances of the various judicial institutions in the countries? For example, the policing as the investigative mechanism, does it qualify to be able to do the functions that are expected of it in terms of the international norms? The prosecutors' officers, do they, on the same basis, can we judge them? And justice. The judges. If the type of political system controls these institutions and make sure that they function according to that will, how can we ignore developing indicators of finding that out? And is there any way to find it out except through the victims of these systems and those who work for these systems? And mere statistics provided by governments or related agencies will not tell that story. The story has to be found out from the people who suffer from these, and that is the general population. And what kind of thinking is going on around this issue? Thank you.
Thank you. Let us have a third question, and then we come back to the panel for remarks.
Thank you very much for your very insightful presentations. My name is Nicholas Ortiz. I'm from Leiden University. I'm a research and teaching associate. And my question is for Bertrand. I wanted to ask you if the draft convention on crimes against humanity is the next part or next step towards this sensitization that you mentioned of ICL. Thank you.
Thank you very much. So let us now hear remarks from our panel members, all of you. Just perhaps to add also, as we do have our Justice for All report, and a lot has been talked about the reaffirmation of universality, and we see these SDGs, the Sustainable Development Goals, it's not just anymore about the developing countries, it's all the countries of the world. And to achieve that justice for all, for all means also those that have been left behind in many ways. But to get there, what is the report really hinting at is that we have to shift the type of justice that we focus on. Do we have to combine? Do we have what is the way forward in terms of actually getting that justice for all? I think rethinking our justice systems in many ways. So let us start maybe with Marieke and then Micah and Dr. Bertrand.
I think both the first two questions that were asked are very legitimate questions. I mean, the first one is a little bit about what's going to be different this time and what's going to move us from commitments to compliance as part of this agenda. And the second one was also a bit about what's going to be different this time. How do we, if we're investing in these institutions, we're not using the tools that we have to measure whether they are captured by elites or corrupt or serving the people, then what's going to be different? So I think the breakthrough that is part of this report and part of these efforts is really to ask everyone, to ask governments to look at justice in this more people-centered way. So instead of taking the institutions and institution building as a starting point, which we know actually from the rule of law field and from decades of experience has not been very effective, because even though we invest in capacity building, we've built courthouses and prisons, etc., we've not significantly improved the rule of law situation in many countries because of the politics, quite frankly, because, the wrong people are in charge and they end up using those institutions against the citizens. In Dutch development policy, we acknowledge this, and we actually try to look at, siding in a way with the citizen instead of with the state. So we have concepts such as human security instead of state security. But I think this idea of people-centeredness takes us much further, because if we work in a people-centered way, then we can look at, for instance, in Afghanistan, a woman may be victim of domestic abuse. So our question then is, how can we find out where she goes with that problem? Who can she complain to? Can she go to the police? Or will she be locked up for having left the house under suspicion of prostitution? What is her justice journey, quite literally? What are her needs? What is her journey? And once we have the data on that from her perspective, then we can start to think about the solutions. This is far-reaching, and I think it's revolutionary. As some talked about this morning, this will lead to some very tough conversations on the state level, because indeed nobody likes to hear if they're not doing a good job. But it's problem-oriented and it's people-oriented, and I think that's new. But I also do think we have a long way to go, to answer Vivian's question, before we can get from that in principle interest and commitment under the SDGs to actual change and implementation. That's going to be the matter of years, if not decades. But, you know, under the MDGs, there were significant reductions in world poverty, and many of the MDGs were met. So maybe through concretizing this agenda, we should be optimistic that we can also achieve significant progress, even within a discernible time.
Okay. Yeah, thank you. I would like to echo that. Some of the questions were international criminal law questions that I dare not answer in this house with international criminal law experts, which I am not. But I liked the two questions that you asked. Why do states become party to human rights treaties, and does this lead to compliance? Because they are empirical questions, in my understanding, and I think that is a very important way of making progress as a justice sector. And I would like to compare, in that sense, and we do this also in the report, the justice sector compared to other sectors, to the health sector and the education sector. And Marika just said that the MDGs drove a whole process in those sectors of getting organized around shared goals, shared understanding of what the problems are, shared measurement methodologies. When the first data on the on people living in extreme poverty was presented, it was very preliminary data. It was an initial estimate, but the numbers were presented, and then that led to a process of people looking at the definitions, looking at the methodology, making progress over time in how you look at these issues. So I think, and the same for the costing, so this is both the legal needs measurement side, the justice gap, and making the case for investment and costing estimates. The task force has not done more than set a few first steps on this road of developing those areas of work. I think, as Marika also said, I think even in her remarks earlier, in that framework of the justice gap, we identify those three different groups, and the report really says the least about that group of 253 million people living in extreme cases of injustice. And I think the world is also looking to this community to help answer some of those questions. And maybe just let me say, well, yeah, echoing the point of asking the right questions, looking at data and evidence, and taking a people-centered approach, I think are key elements of making progress. And lastly, just when I was listening to the principle of contradiction, the great crisis in the world on the one hand, and the promise and hopes of SDG 16, I was thinking of something I read, I can't remember where, somewhere last week, about being the rainbow in the clouds. And so maybe we can see SDG 16 with all its promise and hope and aspirations as a rainbow in the clouds that are definitely also there in the world today.
Since I come from the Caribbean, I will subscribe to the concept of the rainbow, because we're a rainbow people. The Prime Minister of Barbados was speaking in the General Assembly recently, and she said, we must defend the Caribbean civilization, and our civilization is the rainbow civilization. So I'm all for that. Now, let me just take the question very briefly as follows. First of all, Basil, you are the best specialist on deficiencies in the implementation of Article 2, and you published this journal, and you have consistently argued that at the international level, one is not dealing with the realities taking place on the ground. And so now, this is a fundamental challenge, and it's relevant to the answer to the question, the other question that I shall come to. On the question of the Convention on the Crimes Against Humanity, in principle, I have to be supportive of that, because I did my doctoral work on the International Law Commission. And when I studied it, I remember when the General Assembly asked the International Law Commission to formulate the principles of Nuremberg. It was the International Law Commission that did this work, that was then adopted by this building block by block. And so I think that even if the political climate may be difficult at one stage, it's important to continue with the normative work. So then now this question that our colleague raised about commitment and universality. I would like to answer you in the following way. I very much agree with our chair and our rainbow friend there, that I think that this SDG 16, there are many positive and reasons for optimism. I do want to give you the following answer. The strongest body on the implementation of international standards has been the Committee on the Application of Standards of the ILO. And on its 50th anniversary and its 60th anniversary, it adopted the following statement. It matters not what the political, economic, social, cultural, legal, or philosophical system of the country is. What matters is whether the country is giving effect to its obligations under an international treaty. And this standard would be applied by the General Assembly at the beginning when the covenants came into force as well. Nowadays, we are in a period in which the General Assembly and the Human Rights Council, they're emphasizing, quote, dialogue and cooperation. Whatever the issues are, we must dialogue and cooperate. And this is the refrain under the Universal Periodic Review. So therefore, whether I like it or not, we are in a period where the standard is not that of the ILO Committee of Experts, and the strict implementation of the standard is one of dialogue and cooperation. Seen against that spirit, I think it would be fair to say that the Universal Periodic Review is helping to take states, perhaps I want to emphasize, it's probably helping to strengthen commitments and perhaps helping to strengthen the universality. I had occasion recently to look at, to read a book by the Chinese judge on the International Court of Justice. And it is published as, as an independent book. And I think the Chinese judge at the International Court of Justice says the following on this issue of the standard of implementation. China accepts the universality of human rights on the understanding that it is interpreted in the light of socialism with Chinese characteristics. Now think for a moment there. So your question to me was, might SDG 16 take us forward on commitment and on universality? And I want to give you a rainbow answer of possibly yes. And at the same time, I have to deal with the statement. In the light of socialism, you can read it for yourself, Judge Sue Hankin, in the light of socialism with Chinese characteristics. And think about what I said about Mearsheimer. The great powers have no interest in human rights. And so now, judge for yourself. Thank you.
Thank you. With that, we have another round of questions and answers. Let's take 4, and then we can come back to our panel for answering questions, but also final remarks. So please, let's start here.
Thank you so much. My name is Robert Mugisa. To Ms. Mareke, we said that by 2025, 4 out of 5 poor people will be prone to, or will be living in conflict-prone areas. My question is, in light with conflict sensitivity and approaches, is there anything we can do that by 2025, none of those 4 live in conflict-prone areas? So at least we know that by then, and we have some time, is there anything we can do to prevent that?
My name is Rainer Hule from the Nuremberg Human Rights Center. And my question starts from what I see as this panel and also the whole conference is doing, opposing 2 extremes. One, the toughest way we have of enforcing and respecting human rights through international criminal law and courts. and on the other hand, the softest way of stating principles, goals, without a body or instance of enforcing it. Just we may just be confident that the political bodies in the United Nations make some kind of review and some recommendations to the states. So I wonder where you would place in this setting the middleway institutions, the international human rights courts, and also the treaty bodies, who have kind of a bit of each of them. They are not really in a position of enforcing anything, but they are much more than just making soft political recommendations. And I think they would play an important role when we consider this tension between international criminal law and the SDGs. Thank you.
Thank you. Veronica Inestrosa, International Bar Association's Human Rights Institute. So I wanted to ask, you have been telling us that the SDGs should be implemented with a human rights-based perspective, a human rights-based approach. Therefore, they should include meaningful participation, and therefore, there should be people-centered. When I hear the terms fragile state, conflicts at war, countries at war, it always sounds like these countries do not have much to offer to build that justice. And Dr. Vierda was talking about the examples of Colombia and of Uganda that have developed mechanisms to respond to the challenges imposed by international criminal law. What are the organizations you represent doing to make sure that the knowledge that countries like this develop, it's also taken as learning, lessons learned, or mechanisms that could also be implemented? What is the UN doing, the task force? How is the ICC including those local developments into its policies and practices? Thank you.
Let us have a fourth question here. And okay, I see another one. So let's take two more, and then we come back to the questions and answers and final remarks from the panel.
Yeah, Carsten Stahn, Leiden University. My question relates to some of the economical dimension which might underpin the SDGs. We've heard a lot of different conceptions of SDGs. Sam Miller said they're kind of a new social contract that we have between citizens and governments. We've seen basically human rights approaches towards the SDGs, but I would be curious to hear a little bit more to what extent there's actually a rational economic defense of improving access to justice, in which sectors actually this might improve, and whether this might not be actually a more realist incentive basically to ensure compliance and to actually implement something than our traditional basically human rights naming and shaming social contract theories that we have. Thank you.
Thank you. So now, last question.
I have the question, what is in the agenda?
Could you please introduce yourself, please?
Yes, my name is, I'm an artist from Switzerland, and I've got the question, what is in the agenda to prevent conflicts with modern technologies who cannot be handled with the actual laws we have? What are you doing to prevent fields like sexual harassment with modern technologies? Yes.
Thank you very much. We'll now turn back to our panel. And also I would ask all to also give your final remarks or final reflections on our discussion here. This time with Dr. Manchuram.
Well, now, the question of the treaty bodies. I think that the one source, you were a member, you told me, of the Committee on Against Disappearance. The one set of bodies that are still trying to uphold the standard of strict interpretation of the law are the treaty bodies. And as you know yourself, these treaty bodies have come under severe pressure from powerful states on ground of resources, on grounds of time, etc., etc. So I have much respect for what the treaty bodies have done, and we will have to see how the political forces will impact on the treaty bodies. I will leave to my colleagues the issue of the economic aspects of improving access to justice. And then the last question, they're preventing conflicts with, let's just say, new technology or et cetera, et cetera. This can be helpful. Let me tell you, when I was in the Yugoslav peace negotiations, in the midst of a negotiation, the Yugoslav the president of Bosnia would say, I'm not coming to the table any longer because the Serbs have moved their forces against the ceasefire lines. And you have no possibility whatsoever. You have to send soldiers there marching for days. The major powers had the technology, but they wouldn't give us to the United Nations. Now, of course, that technology is available there. And another example is that when Yemen came to us and said, we are going to go to war within 24 hours unless Eritrea removes its forces from the Hanish Islands. If we had the technology at the time to tell us whether or not Eritrea had forces on the Hanish Islands, that would have been very useful. And I know that organizations like Human Rights Watch and the others, they're able now to use satellite technology to kind of map violations of human rights on the ground. So that's as much as I will say to that. As a final comment, I just want to make this last statement. At the Durban World Conference on Racism in 2001, I think it was, so Mayor Robinson was the High Commissioner then, and she asked all states, would you please draw up and adopt a modern vision statement embracing all parts of the population of your countries? This concept of a modern vision statement for every nation that is inclusive and embraces all parts of the population, I see this as a possible avenue of inclusivity and an avenue of strengthening democracy, and possibly as an avenue of promoting justice in the allocation of resources. I'm done. Thank you.
Thank you. Yeah, a lot of questions, and we see the timer here, what you don't know, but we're running out of time. So very quickly, on innovation, yes, there's so much that is possible. There's a sub-report that was developed for the Task Force on Justice, on which has a whole list of innovations that I hadn't even dreamed of in terms of apps, helping people comply with the conditions of their parole, contracts that can be made digitally, et cetera, et cetera. So I would just like to refer you to that. In terms of learning, bringing up these experiences from the local and the national level back to the debate at the international level, I think that is very important. I fully agree. And I think that the justice sector traditionally, of course, international criminal law is an international sector, but if you look at national justice sectors, they are often very focused on their own context, and it is often that, well, every country has its own legal system, there's not much we can exchange. I think that is really not true, even though, of course, every context is specific and the justice system may differ. The needs of people are similar, and the problems that countries are trying to solve are similar. So there's a lot of room for international learning and debate, and that's definitely something that we are trying to promote also with the Pathfinders for Peaceful, Just, and Inclusive Societies. And then lastly, on the economic underpinnings of the SDGs, there's some information in the report, again, too much to go into in these last seconds, but there was an OECD white paper that has made an extensive analysis of the business case for investing in access to justice, and that has drawn, for example, looking at different social sectors, what the impact is of policy decisions and practices that are not evidence-based. Just to name one, a family may be evicted because they are a couple $100 short on paying their rent, but then the social costs of having a family that has no roof over its head can easily go into the thousands, if not $10,000s of dollars. So those kind of economic cost-benefit analysis are not usual in the justice sector, but there's, I would like to refer you to that OECD white paper to have get a sense of the state of that kind of research. Thank you.
Can I just maybe briefly add on the economic issue? What I think is so interesting is that if countries don't provide adequate access to justice, they incur huge costs in other sectors, including in health and in employment and in. So the making the business case paper states very clearly what some of those costs are, and I think it does serve as a great incentive for states to start investing. Very briefly, our colleague from Uganda, I think to you the answer is, actually SDG 16 was specifically for those 4 out of 5 people. So that's why that goal is included in the agenda, to reach them. And prevention is kind of the golden thread throughout the whole SDG agenda, because we also don't know the conflicts of tomorrow. We didn't know the Arab region would erupt into conflict. It seemed relatively stable at some point. So we don't know tomorrow's conflicts, but we should do more on prevention. In that respect, I actually have to disagree a little bit if the SDGs are described as soft by Mr. Reiner. I actually don't think they're that soft. I think they just enable a different kind of conversation. And that can be, I think, very, very helpful. It's back to this concept of universality. They can allow for the conversations on human rights and even on accountability, but they allow for a different language. And in this respect, to agree with Veronica, I think countries that have experienced conflict already or have experienced widespread violations have a lot to teach. And I think transitional justice is indeed a field where we've seen both great innovation at the local level, but we've also seen really countries coming to terms with problems of scale and also using economically very affordable means of justice. Apologies, for instance, needn't cost anything, but it can be extremely meaningful in reaching a justice agenda. So I think there's a lot to say on that, but we're out of time. So in conclusion, I actually don't think the SDGs and ICL are in tension as such, and certainly not normatively. But I think there are significant challenges on the implementation of both. And I think that's where we should put our efforts going forward.
I think we are out of time. By no means I would attempt to summarize the very rich discussion we had in this panel. I only would like to thank the panelists and thank for the participation and the questions that have inspired us here. Thank you.